Mr. Antollino, you know?
What was the initial arraignment date of this defendant in front of Judge Witter?
In front of Judge Witter, well, I don't believe it was the arraignment.
All right. Well, lead us up to the day that he doesn't show up, which is what, early June?
The date that he doesn't show up is, I believe, May 31st.
Right.
And the
was this for an initial arraignment, or?
No.
He'd been arraigned before that?
He had been arraigned before that, and he had appeared as his defense counsel had represented on several occasions.
Had he posted bail, or was he on his own recognizance?
I believe that he had posted bail, Your Honor.
All right. Was the bail ordered to be forfeited on the 11th of June?
I believe that when he was returned to court, that he was remanded, and I believe that the bail was forfeited.
I asked the wrong date. Was bail forfeited on May the 31st, which is when the people say the clock started running?
No, absolutely not, Judge. And I'd just like to state that if you look at the minutes on that date, the judge...
what page?
This, on the appendix, this would be... this would be on page A13 of the appendix. This is the entirety of the court proceeding on which Judge Whitner stayed the warrant. In fact, she didn't even order a warrant by her own language. She just said warrant stayed. So if you want to be technical, she just stayed a warrant. She didn't really order one.
No copy of the warrant was submitted to the grand jury, was it?
No, and there's nothing in the court file as is indicated by the appendix.
So we don't know the date that the court actually directed the defendant's arrest and return for failing to appear.
Well, that is absolutely correct. And I would suggest, Judge, the point is, in this case, is that this is the common parlance of a busy criminal court in New York City. You've got, in some cases, some days, you might have 100 cases on the calendar. You've got this particular exchange. This is less than a page in which the defense attorney and the court are exchanging, and they're speaking in half sentences and phrases that they understand to each other. The court, in this particular case, came to the conclusion, that its own order was absolving the defendant of his appearance on May 31st. That should be entitled to conclusive determination. The court itself has decided that this is what it intended at the time. The appellate division affirmed by unanimous vote of 5 members of a panel that that is what the court had intended. Now, even if, Your Honor, you were to consider this a mixed question of law and fact, and not just a question of fact, those courts are entitled to great deference. They know the custom and practice of the criminal court, and they have determined that this is what the lower court intended. Now, this is a statute that is driven and it is initiated by court order. Contrary to what my opponent tells me, you do want to look at the clear language of the statute, which includes the words court order and required. It is the court order that requires the defendant to appear. So hypothetically, not that it would happen, but hypothetically, someone could be arraigned in the court order, well, I'm not going to make you appear, Mr. Defendant, until the date of trial. And there would be no bail-jumping consequence if he didn't appear. That is what could hypothetically be determined under the statute, which is driven by court order. The sole legal question to this court is whether or not a trial court may amend nunc-pro-tunc, an earlier order that the defendant be required to appear in court. Now, I would suggest that we already know the answer to that question. Courts, in their discretion, amend any number of earlier orders after the fact at any time. The setting of bail, the date in which briefs have to be submitted, substantive legal holdings. Why should the required date under this particular statute be any different? The trial court must be afforded the flexibility and discretion to amend an order that the defendant appear on any particular date. There is no support for the proposition, as my opponent suggests, that it is only prospectively, that the court may amend this order only before the date that the defendant does not appear in court. Where does the statute say that? It doesn't say that anywhere. It's number one. And number two, in terms of a common sense application of the doctrine of judicial discretion. The whole reason we afford judicial discretion is that it's a matter of judicial policy. Appeals courts.
You wouldn't argue that more than 30 days later, after the non-appearance, the court could excuse the non-appearance, could you?
more than 30 days after the non-appearance, the court could excuse him. I would argue, even though that's not the case in this case, I would argue that under certain circumstances, depending on the facts, it could. Depending on the facts.
At least you don't have to argue it, do you?
Well, Your Honor, consider the case that you suggested earlier. You suggested that what if the court adjourned it for more than 30 days? What if that happened in a particular case? And this defendant has appeared for a case that's been adjourned for 18 months, and he's appeared on every single date. And then, 40 days later, he doesn't show up. And the court knows this defendant and has some experience, and in its discretion, it amends its earlier order. Why is it not allowed to do that when the statute says court order, and the statute says required by the court? Why can't the court do that?
Well, thank God we don't have to decide that.
I'm sorry?
We don't have to decide that. That'd be dicta, wouldn't it?
Well, it would be dicta, but it really is, it is a point you should consider in determining this appeal. The whole theory behind judicial discretion is you do not want to micromanage these discretionary acts. And by their suggestion that the court order can be amended only prospectively, they're asking you to do exactly that. Now, as I've suggested earlier, the lower courts are entitled to great deference in this particular case. They are essentially interpreting their own orders. The Supreme Court found that the staying of the warrant was essentially the setting of a new required date, and a unanimous panel of the appellate division decided the same thing. Remember, there's also one case from the second department, which was a county court case which was affirmed by the appellate term in the second department, which came to the same conclusion. These courts know the common practice in their courts, and in that case, it was a warrant letter that was sent out and said, you've got one more chance, essentially. And that's the People against McLean case. That's really the only case that is even remotely on point in this particular case. Finally, I'd like to...
Let me ask you this. When you are using the word prospective in reaction to the other side's using the word prospective,
Yes.
do you understand her to mean by the use of the word prospective that it's no good if it's done any time after May 31, 96?
Though I understand her word perspective to mean any time before May 31st or even the minute before
You can
he
do
doesn't
that
appear.
before, but once you're after May 31st, 96, then the DA's argument is that you can't do it.
No,
Notwithstanding,
I think they would argue that on May 31st, the judge can't do it.
that's right. So anytime before then is okay. Anytime after that, they cannot do it.
On or after, yes.
On or
That's
even
what
though
they're
the judge said warrant stayed.
Yes.
That's all. The judge says warrant stayed. We didn't even know that a warrant was signed.
That's right.
And it looks as though a warrant was not signed.
That's right.
Because in the next session, she says warrant ordered, which means somebody is supposed to prepare a warrant that will somehow or other get to her. Maybe the DA prepares it, and then the judge signs it. But we don't know that anything was signed here, right?
You've got 100 cases on the calendar, possibly, and in this particular case, the judge knows what warrant stayed means, the defense attorney knows, the prosecutor knows, and in another case, matter of Jamar A., this court came to a similar opinion looking at the requirement for findings of fact that have to be made in a juvenile delinquency case, and it held that we're not going to hold busy trial courts to the standard that, in that case, the respondent was asking this court to hold it to. The same principle applies here. You've got a number of cases on the calendar. The court says warrant stayed. Everyone knows what that means, and the court itself has interpreted it to mean that he was absolved at that appearance. For those reasons, I believe you should affirm.
Thank you. People against Christopher Wilder.
Excuse me, my rebuttal.
Oh, sorry.
Just quickly, just to clear up the record,